advances in medical science and socio-economic development may have increased the lifespan of people, but have also changed their end-of-life circumstances. In the past, people often passed away in the company of loved ones at home. Death was sudden. Now, many people spend the end of their lives strapped to tubes in impersonal hospital settings, even when further medical treatment might not help. End-of-life care shifts the focus from cure to care and focuses on comfort, pain relief, and spiritual care for patients so that they can spend the last days of their lives comfortably. What are end-of-life decisions? Key decisions around end-of-life care relate to the withholding or withdrawal of life-sustaining medical treatment, that is, stopping medical treatment or deciding not to initiate medical treatment when further treatment might not help. For example, a decision not to revive a person who has suffered a cardiac arrest, or a decision to take someone off a ventilator. End-of-life decisions are usually taken for terminally ill patients or those in a coma or in a persistent vegetative state. But what's the law got to do with it? The law has always recognized the rights of patients with capacity to take decisions about their medical treatment. In 2017, in the case of Justice Retired K.S. Puttaswamy versus the Union of India, the judges recognized that the right to privacy includes the right to refuse life-sustaining medical treatment. If a person who possesses the capacity to understand the consequences of their decisions refuses such treatment, then the treating team must respect this. Any treatment against a person's wishes might make the doctor liable to an action for assault or battery. But often in the end-of-life care context, patients lack the capacity to make such decisions. This situation arose before the Supreme Court in Aruna Shanbag's case. Aruna Shanbag was a nurse who remained in a persistent vegetative state for over 40 years after being sexually assaulted. When the Supreme Court was petitioned to allow Ms. Shanbag to stop being fed, it laid down an important principle that life-sustaining treatment could legally be withheld or withdrawn even when the person in question doesn't possess capacity. In such cases, these decisions fall on surrogates, who often end up being close family members present at the hospital. However, even in such cases, a person can retain control over their treatment even if they end up in a coma or in a persistent vegetative state. They can do this by expressing their wishes about treatment in advance through instruments called advance directives or living wills. In 2018, a constitution bench of the Supreme Court in Common Cause versus Union of India recognized the legal validity of advance directives or living wills and laid down guidelines to bring them into operation. What are advance directives or living wills? Advance directives or living wills are expressions of patient autonomy. They demonstrate the high regard that healthcare decision-making places on the wishes of patients. They are essentially statements made by persons when they possess capacity regarding healthcare decision-making for a time when they might lose such capacity. They may also be used to appoint surrogates who can take decisions on the behalf of such patients. Advance directives cannot be used by patients to demand specific kinds of treatment. Doctors are not under an obligation to provide medical treatment that they do not believe to be in the best interests of the patient. For example, an advance directive cannot state that a person should be ventilated in all circumstances. How can you make an advance directive in India? Under the guidelines laid down by the Supreme Court in Common Cause versus Union of India, you can make an advance directive if you are of sound mind and you are at least 18 years old. You should make and sign the directive voluntarily and with informed consent. The directive should clearly state when medical treatment should be removed or when it should not be given. The directive must be clear and specific and must also appoint a surrogate who can take decisions on your behalf when you lose capacity. 2 witnesses should witness the making of the advance directive, and a judicial magistrate of the first class, designated for that purpose by a district judge, should countersign it. Judicial magistrate of the first class should retain a copy of the advance directive, and the jurisdictional district court will also store a copy at its registry. You can share a copy of the advance directive with your immediate family members, with officials of local government, and with your family doctor. How will advance directives be given effect to? The Supreme Court has laid down a detailed process for the operationalization of advance directives for patients who are admitted to hospital. In the first instance, a hospital-appointed medical board will determine the condition of the patient and decide whether advance directives should be given effect to. Thereafter, an external medical board appointed by a collector will confirm the opinion of the first board. If the external board agrees with the first hospital-appointed medical board, then the judicial magistrate of the first class will visit the patient in hospital and authorize the removal of life-sustaining treatment. If either of the 2 boards does not authorize the removal of treatment, then the family members of the patient may approach the High Court for its removal. Although the Supreme Court guidelines were issued as far back as 2018, to date little has been done to create mechanisms to implement them. Given how time-consuming the Supreme Court mandated steps are, contrasted with how quickly decisions must be taken in real-life critical care settings, the guidelines have not been implemented in practice. As a result, hospitals like the All India Institute of Medical Sciences, New Delhi, have come up with their own internal policies on end-of-life decision-making that are based on sound, ethical, and legal principles. What are do not attempt resuscitation or DNAR decisions? DNAR decisions or do not attempt resuscitation decisions deal with the administration of CPR or cardiopulmonary resuscitation. Recently, the Indian Council of Medical Research laid down consensus guidelines on DNR decisions. These guidelines state that CPR, which often poses risks and which may not always be as successful as it is portrayed to be in popular culture, should be undertaken only after informed conversations between doctors and patients or their relatives or family members. In cases where CPR might not be beneficial, and after consultations between the doctor and the patient or family members, a DNR order may be issued by a doctor. This will state that CPR should not be administered should the patient's heart and/or lungs stop functioning. This is an important step towards ensuring ethically sound end-of-life decision-making and preventing the administration of non-beneficial medical treatment after accounting for the patient's wishes.